Good afternoon. The Subcommittee on the Federal Workforce, U.S. Postal Service, and the Census will come to order. I'd like to begin this hearing by stating the Oversight Committee mission statement. We exist to secure two fundamental principles. First, Americans have a right to know the money Washington takes for them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. We will work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. This is the mission of the Oversight and Government Reform Committee. I'll now start with my opening statement. One of the most important functions of the Oversight Committee is to help expose waste, fraud, and abuse within the Federal bureaucracy, and to help reform broken institutions and policies that ensure taxpayers that they have a government that works for them. As members of this committee know, whistleblowers are an invaluable asset in helping us achieve this important goal. Unfortunately, those who expose waste, fraud, and abuse from the inside sometimes only receive retaliation as their reward. Today's hearing will examine how whistleblower protection laws are often ignored or manipulated. The result is that those in a position to shine light on illegal behavior stay in the shadows for fear of retribution. This committee has a long history of working with whistleblowers. They aid in our investigations, and we appropriately have legislative jurisdiction over laws that provide them protections. In 2012, we updated the Whistleblower Protection Act to expand existing disclosure protections and to create new avenues for appellate review outside the Federal Circuit, which has historically not been friendly to whistleblowers. I want to hear how the newest amendments to the law are working and whether or not the executive branch is violating either the letter or the spirit of the law. I am also pleased that two brave whistleblowers are with us today so we can hear firsthand accounts of the good, the bad, and ugly of doing the right thing and coming forward to report misdeeds in their own agency. I want to thank you all for your service, courage, and willingness to speak today. Congress must do everything in its power to help protect well-intentioned individuals who help Congress and the public know when improper behavior occurs within the Federal bureaucracy. Again, I would like to thank all the witnesses for participating today. I will now recognize the ranking member, the gentleman from Massachusetts, Mr. Lynch, for his opening statement.
Thank you, Mr. Chairman. I appreciate you holding this hearing to examine the treatment of whistleblowers. I also thank our witnesses for being here today and helping the committee with its work, and I look forward to your testimony. Federal whistleblowers serve a valuable role in identifying waste, fraud, and abuse across the Federal Government. In many cases, the diligent oversight efforts undertaken by these government watchdogs shine a light on government abuse, and as a result, we are better able to safeguard American lives and mitigate the waste of American taxpayer resources. It is these brave men and women who inform the American people about the government's delay in delivering armored cars to Iraq and Afghanistan to reduce combat casualties from improvised explosive devices. Federal whistleblowers have also detailed the cancellation of U.S. air marshals from flight protection duties despite the existence of confirmed and continued threats of potential terrorist hijackings. These dedicated government employees also reported the diversion of research funds that were set aside to treat veterans with traumatic brain injuries. For many of these whistleblowers, doing the right thing and disclosing violations of law and fraud, waste, and abuse comes at a high price. Many have been subjected to acts of retaliation, including the elimination of their job duties, reassignment to positions of no consequence, geographical locations such as the relocation of their desks to basements or closets, misconduct investigations, suspensions, and terminations. Mr. McLean and Dr. Van Boven will testify how much their lives and the lives of their families were disrupted as a result of their retaliation that they faced. Unfortunately, whistleblower retaliation has been a long-standing problem over multiple administrations. Much has been accomplished to enhance whistleblower protections. Congress, with the support and commitment of President Obama, passed the Bipartisan Whistleblower Protection Enhancement Act in 2012 after more than a decade of reform efforts. This Act strengthened protections for Federal employees by closing judicially created loopholes and extended new protections for government scientists and certain Transportation Security Administration employees. The bill also created a 2-year pilot. That same year, the Administration also extended whistleblower protections to intelligence community employees through a presidential directive. Congress then followed through this year by codifying protections for national security employees in the Intelligence Authorization Act. Although Congress and the Administration can provide protections and avenues for redress, we cannot legislate culture. That can only change by determined leadership, constant attention from Congress, strong employee representatives, and strong Federal employee unions and vocal advocates. Despite the progress we have made, our work is not yet complete, and I look forward to hearing from our witnesses about how much further we need to go. Thank you, Mr. Chairman. I yield back the balance of my time.
Thank you, Mr. Lynch. Members will have 7 days to submit opening statements for the record. We will now recognize our panel. The Honorable Carolyn Lerner is the head of the U.S. Office of Special Counsel. The Honorable Susan Suey Grunderman is the Chairman of the U.S. Merit System Protection Board. Mr. Robert McLean is a former employee of the U.S. Transportation Security Administration. Dr. Robert Van Boven is a former employee at the U.S. Department of Veterans Affairs. And Mr. Tom Devine is the Legal Director at the Government Accountability Project. Pursuant to committee rules, all witnesses will be sworn before they testify. Would you please stand and raise your right hand? Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect that all witnesses answered in the affirmative. You may be seated now. We want to hear your opening testimony, but we also want to have the opportunity to question you. So we have your, those of you who submitted written testimony, we have your written testimony in front of us and have hopefully read it. And so in order to allow for discussion, we'd appreciate your summarizing and hitting the high points and limiting your remarks to as close to 5 minutes as possible. You'll see a countdown timer in front of you. Much like the traffic lights we're all familiar with, green means go, yellow means speed up, and red means stop. So we'll now start with Ms. Lerner. You're recognized for about 5 minutes.
Thank you, Chairman Farenthold, Ranking Member Lynch, members of the committee. Thank you for inviting me to testify today about the Office of Special Counsel and its protection of Federal whistleblowers. In addition to protecting whistleblowers, we provide a safe channel for employees to disclose government wrongdoing. We enforce the Hatch Act, which keeps partisan politics out of the Federal workforce, and we protect returning service members from unfair employment practices. We do all of this with a staff of about 120 and one of the smallest budgets of any law enforcement agency. When I was appointed Special Counsel 3 years ago, among my top goals was increasing awareness about and confidence in the agency. I believe we are succeeding on both fronts. This fiscal year, we expect to receive over 5,000 cases for the first time in the agency's history, a 15% increase from last year and double the number of cases from 10 years ago. Clearly, Federal employees now know who we are and feel confident coming to our agency, and we are getting great results on their behalf. In the past 2 years, we've obtained 333 favorable actions for employees, about a 400% increase from 5 years ago. And we have done so while reducing the cost to resolve each case by over 40%. With that introduction, I will now briefly discuss how we protect whistleblowers, the effect of the Whistleblower Protection Enhancement Act on OSC, and our education and outreach efforts. When reviewing a whistleblower retaliation complaint, OSC's Complaint Examining Unit performs an initial review to determine if the complaint meets required elements. If it does, the matter is referred for further investigation. After we investigate, agencies often informally settle cases and take corrective action. If an agency does not, we may then file a complaint with the MSPB, which can order the agency to do so. Similarly, if an agency fails to take appropriate disciplinary action, we can file a complaint with the Board. OSC is able to protect complainants by seeking to delay or stay proposed adverse personnel actions, either informally with the agency or by filing a formal request with the MSPB. These stays provide temporary relief while OSC investigates. Another tool that we use to get corrective actions is mediation. Very often, mediation resolves complaints to the mutual satisfaction of both agencies and complainants without the need for a full investigation or litigation. For instance, in 2012, 3 employees of the Bureau of Alcohol, Tobacco, and Firearms who blew the whistle on Operation Fast and Furious resolved their cases through OSC's mediation program. The Whistleblower Protection Enhancement Act, which this committee worked hard to enact, has also strengthened OSC's ability to protect whistleblowers. The WPEA expanded OSC's jurisdiction, allowing us to take complaints that we previously would have had to dismiss due to narrow court interpretations of whistleblower protections. The WPEA also improved OSC's ability to pursue disciplinary actions. For example, we recently filed complaints with the MSPB seeking disciplinary action against 3 Customs and Border Protection officials. The WPEA also expanded OSC's authority to file amicus curiae briefs in cases related to Federal whistleblower retaliation. OSC has filed 3 amicus briefs in Federal courts, including one just this past month, and we are currently in discussions with the Department of Justice about OSC filing an amicus brief in the U.S. Supreme Court later this month in the McLean versus Department of Homeland Security matter. This would follow the amicus brief that we filed in Mr. McLean's case with the MSPB in August 2011. These briefs are meant to help courts interpret the contours of whistleblower laws. We are optimistic that over time this will lead to more pro-whistleblower body of jurisprudence. Finally, I want to very briefly address our education and outreach efforts in OSC's certification program. Government functions best and can address problems most effectively when employees can come forward without fear of retaliation. Creating this environment requires education, educating employees about their rights and managers about their responsibilities. Accordingly, we have recently expanded our outreach and education efforts. In fiscal year 14, we have conducted 90 training sessions throughout the Federal Government. This compares with 33 sessions just 3 years ago. We are also seeing an increase in the number of agencies seeking OSC's assistance in training employees on whistleblower laws. This positive increase is due in large part to the Administration's recent requirement that agencies become certified through OSC's program. I'd be happy to address this issue or any other in more detail in response to any of your questions. Thank you very much for the opportunity to testify today.
Thank you very much, Ms. Lerner. Ms. Grunderman, ball's in your court now.
Thank you, Mr. Chairman, Ranking Member Lynch, distinguished members of this committee, including Mr. Congressman Cummings and Congresswoman Norton, who used to be my negotiations law professor back at Georgetown. Good to see you again. I'm still sitting on the other side of the table. Thank you for the opportunity to appear before you today and testify on behalf of the Merit Systems Protection Board. Let me acknowledge the presence of my distinguished colleagues and fellow board members, the Vice Chair Ann Wagner, Member Mark Robbins, and thank them for their strong contributions to fulfilling the Board's mission. It has been a great personal honor for me to serve with these 2 dedicated individuals. Today, we've been asked to discuss the Board's role in defending the merit principles and specifically our role in appellate review of the Federal whistleblowers. We will address our recent observations of whistleblower appeals, the impact of the Whistleblower Protection Enhancement Act of 2012 on Federal employee whistleblowers and the Board itself. The mission of the Merit Systems Protection Board is to safeguard, protect, and promote the merit principles through its statutory functions. One function is to adjudicate appeals filed by Federal employees. Under the Whistleblower Protection Act of 1989, the Board has jurisdiction over 2 types of appeals. One is referred to as IRA, an individual right of action. This appeal is of a nature that involves allegations of whistleblowing that are not directly appealable to the Board. This means that before a whistleblower may file an IRA with the Board, that he or she is first required to seek corrective action from the Office of Special Counsel. Generally, only after the Special Counsel investigates the claim and determines not to pursue corrective action is the employee then allowed to file an IRA with us. The other type of whistleblower appeal is referred to as an otherwise appealable action. This type of appeal generally involves a claim that a personnel action, such as a termination or suspension, was taken in retaliation for whistleblowing. In either type of appeal, the Board must determine whether the agency illegally retaliated against Federal employees for disclosing what the employee reasonably believes falls in one of 4 categories. 1, a violation of law, rule, or regulation. 2, gross mismanagement or waste of funds. 3, an abuse of authority. 4, a substantial and specific danger to public health or safety. Upon a ruling by the Board, an employee may then appeal to the U.S. Court of Appeals for the Federal Circuit and, as a result of the Enhancement Act, at least till the end of this year, to any other Court of Appeals of competent jurisdiction. We are currently aware of only 4 Board decisions on whistleblowing that have been appealed outside the Federal Circuit. We understand that the House of Representatives has already passed legislation extending this provision an additional 3 years, and that such legislation is now awaiting action in the Senate. As to the number of whistleblowing appeals, any trends we may be aware of, since last fiscal year, the number of whistleblower appeals has dramatically increased. What may be of interest to this subcommittee, and particularly to Congressman Cummings, is that the number of appeals jumped from 485 in fiscal year 12 to 657 in 13 after the enactment of the Enhancement Act. Whether there is a correlation between these two events, we cannot say, but we can certainly say that Federal employees are filing whistleblower appeals with the Board more than at any other point in the last decade. Regarding trends in whistleblowing appeals, we can say that as a result of the Enhancement Act, which greatly expanded the protections for whistleblowers by overruling a long line of cases by the Federal Circuit, we understand that more whistleblower appeals are advancing to a hearing on the merits before administrative judges, that those hearings are much more detailed and lengthier in duration, and that more cases are obtaining a merits review by the full Board in Washington, D.C. And while the numbers in our report in fiscal year 13 are based on outcomes achieved under the prior law, and we look forward to fiscal 14, which will provide a full year of data under the new Enhancement Act, already we can see the impact of the Enhancement Act in our cases. In our written statement, we have included a list of presidential decisions issued by the Board under the new law. Of the 11 decisions listed, the appellant's case and claims succeeded in 6, all 6 of which were IRAs. Another issue we believe of interest to the subcommittee is the Federal Circuit's recent decision en banc in a case called Kaplan versus Conyers. The decision in Conyers, the issue was simple. May the Board review an agency's determination that an employee is not eligible to occupy a position that is classified as non-critical sensitive. In that case, our agency argued that by limiting the Board's review in these types of appeals, that the Federal Circuit's ultimate decision could have the effect of precluding whistleblower claims by employees in positions at issue. The Federal Circuit dismissed this argument. The Supreme Court declined to hear the case. We understand that the House and Senate are considering legislation that would reverse this decision. In addition to our adjudication function, the Board is tasked to conduct studies relating to the civil service and other merit systems in the executive branch. Since 2010, we've issued a series of reports, including one that may be of interest to Member Lynch, as we discuss a change in culture of agencies in order to allow whistleblowers to come forward. In the near future, the Board is looking at studying the specific impact of the Whistleblower Protection Act of 2012, agency implementation of the Act, and the change of law in the landscape of the Act. This concludes my statement. I look forward to answering your questions. Thank you.
Thank you very much. Mr. McLean, look forward to hearing your story.
Thank you, Mr. Chairman, and Ranking Member Lynch and Ranking Member Cummings. I was in the first class of 35 Air Marshals to graduate after the 9/11 attacks of '01. In '03, a perfect storm hit. All marshals were called in for emergency training. Al-Qaeda hijackers would exploit U.S. Department of State visa and checkpoint screening loopholes in order to sneak weapons onto long-haul flights, kill crews, and crash their jets. Briefers were specific to major U.S. East Coast cities and European capitals. 2 days later, TSA blasted out an unmarked text message to all marshals' unsecured cell phones. Cancel all hotel reservations to avoid all cancellation fees. Flights for 4 hours or longer wouldn't have had marshals for 2 months until TSA got its new fiscal year funds. Marshals around the country told me that they got the same text. We thought it was a mistake, given the alert and a very specific law that 9/11 type flights must be covered. I called a supervisor who confirmed TSA formed a global plan because it was broke. I called 3 IG offices until I spoke to an agent detailed from FEMA. He just warned me about risking my career. Since the text was not specific, it was not marked nor secured, I called a reporter covering TSA's dangerous rules. He verified with marshals across the country and was in contact with Congress. The story went on the web. Hours later, most press had coverage of outraged bipartisan members of Congress, including Hal Rogers, the Republican chairman with the oversight of the TSA. After first denying it, TSA said it made a mistake and canceled its plan before ever taking effect. The IG said the TSA blew cash on executive bonuses. Weeks later, I co-founded the Air Marshal chapter of the Federal Law Enforcement Officers Association. FLEOA, it's not a union, but a collective voice to work with Congress and agency officials to better safety and security. The Air Marshal Service Director asked the IG to investigate me and my FLEO Air Marshal Board for complaining about hazardous policies. He called us organizational terrorists. For 2 years, we worked with Chairman Jim Sensenbrenner's Judiciary Committee. In 2006, he issued a 147-page report about the Air Marshal's dangerous policies and retaliation against us FLEOA representatives. None of this was considered retaliatory because the director and his executive who fired me, Frank Donzani, later testified that they were all at one time FLEOA members. Mr. Donzani told me I was under suspicion for disclosing unclassified sensitive security information, or SSI. Internal Affairs ordered me to divulge all media I was a source for. I admitted to everything, as it was all unclassified at the time, and everyone agreed with me, Congress, bipartisan. But a decade later, I've been second-guessed in hundreds of briefs and hearings and depositions. Dumbfounded for 19 weeks, TSA finally concocted its single charge to fire me. The text message it chose not to send to our $22 million encrypted smartphone system was now SSI. TSA forced its SSI chief in charge when I made my disclosure not to show up for his ordered deposition and replaced him with an attorney who was with the Postal Service when I made my disclosure. TSA was a little nervous. Its attorneys interrupted him 252 times during his deposition. This was the TSA's expert on SSI, who didn't come to the TSA long after I made my disclosure. Mr. Donzani was the only witness allowed in my hearing 3 years later. Everyone else was denied. Despite unbelievable excuse why he didn't have the authority to ground me for almost 5 months, the fact that he was permanently removed from all supervisory duties just weeks after my hearing, Mr. Donzani's credibility was never scrutinized. Despite a precedential decision, a unanimous Ninth Circuit Court of Appeals panel ordered that TSA's 03 program's lack of clarity must be considered. But all of the TSA's SSI experts were blocked from my hearing. Last year, in another precedential decision, the Court of Appeals for the Federal Circuit unanimously ruled I did not violate any laws and ordered a new hearing to determine if I had a reasonable belief of any wrongdoing. The government en banc appealed that decision to every Federal Circuit judge. It was denied unanimously. Finally, Mr. Chairman and Ranking Member Lynch, TSA took my testimony out of context to cancel the Ninth Circuit's it was unanimous, good faith belief order. It quoted me as saying that it didn't matter to me if I disclosed SSI to the public. But what the transcript reveals is that I stated that it did not matter if I disclosed SSI to my supervisor. It was a perfect cut and paste job. With that, the government now argues in its current appeal to the Supreme Court of the United States that I, quote, intentionally release sensitive security information, unquote. My oral arguments before the Supreme Court are November 4th. I look forward to answering your questions. Sorry for going over time.
You didn't do too badly. Dr. Van Boven, you're recognized here for 5 minutes.
Thank you. I'm a physician scientist.
Could you make sure your microphone is turned on there? There's a button there that says talk on it.
I'm a physician scientist and was the director of the Department of Veterans Affairs Central Texas Traumatic Brain Injury Research Program in Austin from 2007 to 2009. Beginning in 2002, the VA and University of Texas agreed to jointly build a brain imaging center in Austin, and the VA invested $6.3 million. The center was opened in January of 2006, but recruiting for a director did not start for 6 months. I was recruited a year and a half later in July. Troop deployments at the time were averaging 22,000 service persons per year, with 6,000 TBI victims annually. With over 300,000 military TBI casualties worldwide since 2000 and 2 million annual civilian cases, advances to make these invisible wounds visible and to develop effective treatments for TBI were and remain to be sorely needed. With training at Harvard Northwestern University and 7 years postdoctoral research at Hopkins and the NIH, I felt this was a perfect opportunity for a neurologist scientist to make a difference. But within weeks at the helm, I learned that $2.1 million, approximately one-third of the funds provided to the Burrell, or Brain Imaging Recovery Lab, had already been spent on ghost staff, as well as unqualified administrative clinician performing non-credible diabetic research unrelated to TBI. He depended on the technical support of a semi-retired research contractor who hadn't published in 10 years. He had been fired from his immediate past employer and engaged in billing which I believed to be fraudulent. The team had not collected any data for 10 months. Findings were subsequently confirmed by the OIG. Now, my efforts to terminate the contracting services and invalid research were overruled. My protest resulted in calls for my resignation and involuntary reassignment under a person I accused of wrongdoing. The retaliation and counterclaims that followed were akin to Kafka's The Trial. False allegations were withheld from me. I was not able to confront witnesses. Evidence of retaliatory animus by those accused of wrongdoing were stricken from the scope of investigations, and I was found guilty without an opportunity for defense. An administrative board of investigation was manipulated with brazen disregard for VA policies and due process and fairness, and the ABI called in response to my complaints was later amended to add a long list of counterclaims. Patriotism was also punished. That is, I was condemned for volunteering to organize a 5K run for wounded warriors with Governor Perry, Willie Nelson, and 1,000 Americans. Later, the ABI scope and justice itself was turned upside down. The scope is now restricted to allegations against me. The new ABI was reconvened despite an ongoing OIG investigation, which is violation of VA policies. Its chair was a past subordinate of an official alleged of wrongdoing, and during the ABI hearing, any mention of senior management misconduct or waste was stymied. The Chief of Staff was also authorized by the VA headquarters to be the deciding authority for a grievance against him. And this Chief of Staff found himself not guilty. After removal from the Burrell in 2008, I was banned from oversight of my own human studies, posing risks to subjects and violating all kinds of VA policies. The center was idle but still burning money. It was moved to Waco in July of 2009, and most of the $6.3 million was spent without studying or helping a single veteran. Many of my complaints to the OIG and the ORO were substantiated by these investigations, in part prompted by Washington Post coverage. The ABI grievance hearings and the VA Summary Review Board defied the Whistleblower Protection Act's principles and engaged in unjust practices in their own right, and did a good job of it. The VA attempted to suppress information from Congress. Moments before the Merit System Protection Board hearing, VA officials asked if I would stop initiating contact with Congress and others for a settlement. Settlement was accepted because I was advised that corrective action by the Merit System Protection Board was unrealistic. In fiscal year 13, the MSPB granted 4 out of 657 persons, that is less than 1%, with corrective action after adjudication for appeals with whistleblower reprisal claims. Even after my termination, the VA continued to engage in harmful retribution, blacklisting me with marathon persistence. Past failings in transparency and mismanagement are indeed prologue. VA officials later testified before Congress again in 2010, falsely claiming that personnel at Waco, with a director who had a nicotine expert, had TBI and neuroimaging expertise, hence justifying the borough's closure. I had been contacted by a Waco whistleblower later that told the opposite story, and he was persecuted for it, and indeed I referred him to the Government Accountability Project, and he's being represented then. 4 years later, deceit was revealed. A second failed program now, overseen by the same officials that oversaw the borough, is covered in the obituary section, I mean the front pages. It may as well have been the obituary section of the Austin Statesman this past Sunday. The article points out that the two imaging programs, the borough and Waco, cost taxpayers $12 million and squandered a decade of opportunity. Ironically, through a congressionally directed medical research program award, one of 3 in the nation, I and colleagues at MIT, UCSF, and the Department of Defense are now helping and carrying out a treatment trial at Fort Hood. That's covered by the Sentinel. So with over $1 billion a year in research budgetary resources and appropriations, and the same for medical support like the borough, scrutiny of the VA research management program and oversight appears worthy. Now, in conclusion, delivering help to those who are afflicted with brain disorders from TBI and post-traumatic stress disorder is dependent on good science and integrity. I'm a clinician. I take care of people with brain injuries daily. However, if a culture fights rather than fosters transparency, that suppresses rather than rises to the opportunity for improvement, then the infamous stereotypes will continue to curse the VA bureaucracy and degrade the whistleblower alike, and the public will suffer. Whistleblowers have their roots in stopping crime. They need your protection from persecution and denigration so they can help transparency, integrity, and performance in government today. I thank you.
Thank you very much, Doctor. And I did see the article in the Statesman this weekend after the Texas football game. It was much more interesting than the sports pages. Mr. Devine.
Thank you. I'm the legal director.
And we're going to, could you hit your microphone too, please, sir?
Thank you, sir. I'm the legal director of the Government Accountability Project. We're a nonpartisan, nonprofit whistleblower support organization that since 1977 has helped over 6,000 whistleblowers and been a leader in the campaigns to pass or defend nearly all federal whistleblower laws. We're also a founding member of the Make It Safe Coalition, which is the tip of an iceberg for a unique trans-ideological bipartisan solidarity consensus between voters and whistleblowers. Our coalition recruited over 400 organizations and corporations with some 80 million members to support passage of the Whistleblower Protection Enhancement Act. They ranged from the Center for American Progress, Common Cause, the unions, Public Citizen, to the Liberty Coalition, the National Taxpayers Union, the Taxpayers Protection Alliance, the Competitive Enterprise Institute, the American Conservative Defense Alliance, and the American Policy Center. This is an unprecedented mandate for the values of your hearing. But for whistleblowers, the nearly 2 years since passage of the WPEA have been the best and the worst of times. There's unfinished business, and how it is resolved will complete the struggle. I'd like to summarize 5 areas where there are challenges or hard work left to achieve the Act's promise. The first is the sensitive jobs loophole. The decision that Chairman Grunman summarized by the Federal Circuit Court of Appeals, Kaplan versus Conyers, has created the most significant threat to the merit system that has kept the civil service professional and nonpartisan since 1883. I won't repeat the arguments that the Chairman made, but where the dust is settled is that the government now has uncontrolled power to designate virtually any job in the government as sensitive. The Federal Circuit applied the principle to those who stock sunglasses at commissaries. Proposed regulations by the Office of Personnel Management would permit designation for all jobs that require access to either classified or unclassified information. In other words, all jobs that require literacy are sensitive now. Sensitive employees will no longer be entitled to defend themselves through an independent due process hearing, and there are no consistent procedures for justice within the agencies. The bottom line is this is a structure to replace the merit system with a functional blank check for a national security spoils system. That is simply unacceptable. Second is the McLean case that Mr. McLean has testified on. He testified on what happened to him. I'd like to testify on the significance for the WPEA. This November, the Supreme Court will hear its first WPA case, Whistleblower Protection Act case, since the law was enacted. At stake are the two most basic significant premises for this law. First, that only Congress can restrict public whistleblowing disclosures, not the agencies who allegedly engaged in fraud, waste, abuse, illegality, or activities threatening the public. Otherwise, wrongdoers would have the right to gag whistleblowers exposing their own misconduct. Second, when Congress restricts public whistleblowing disclosures, it must do so with specificity. Otherwise, employees will have to guess whether they have legal rights when they serve the public's right to know, and uncertainty creates an inherent chilling effect. An adverse ruling would cancel everything that we had accomplished in the Whistleblower Protection Enhancement Act. We believe a congressional friend of the court brief from Mr. Cummings, as well as others at the Federal Circuit, made a major difference in the results. And we're recruiting participants for a congressional friend of the court brief to the Supreme Court. The third issue is circumventing the whistleblower protection rights by making it a crime to blow the whistle instead of an employment offense. The war on whistleblowers goes well beyond unprecedented Espionage Act prosecutions. Since passage of the WPEA, we've seen a sharp shift from traditional employment actions to criminal investigations and prosecutive referrals. It's increasingly, whistleblowers are given the choice of resigning or risking jail time. Ernie Fitzgerald once nicknamed whistleblowing as committing the truth because you're treated like you committed a crime, and this literally is becoming the new reality. It's not surprising. Criminal investigations are much easier and less burdensome than multi-year litigation. There's no risk of losing. All you have to do is close the case. And the chilling effect of facing jail time is much more severe than facing an adverse action. This problem could easily be fixed by codifying legislative history through the 1994 amendments of the WPEA. And finally, there are pending WPEA issues that are confronting us. They're confronting us from the remainder of the Whistleblower Protection Enhancement Act, whether there should continue to be normal access to appeals courts, whether civil service employees like corporate whistleblowers should have access to court in a jury trial if they don't get timely rulings, and whether the MSPB should have summary judgment authority. There is also hard work to continue and resume from the OSC MSPB reauthorization. In 2007, this committee prepared legislation and marked it up through subcommittee to make over and modernize these institutions, which haven't had that upgrade since 1978. Further action was postponed until the WPEA, and it's time to roll up our sleeves and get to work on it. Mr. Chair, the WPEA was landmark legislation to restore rights that Congress has now passed unanimously 4 times since 1978. But the pressure to enforce abuses of secrecy through silence also is timeless, trans-ideological, and bipartisan. The WPEA's most significant issues have not yet been resolved, and agency creativity is already producing new, more intimidating forms of harassment. The rules that govern the merit system procedures are increasingly coming out of date. Our work isn't finished, and the whistleblower community in GAP stands ready to do our share.
Thank you very much, Mr. Devine. I'll now recognize myself for the first round of questioning. Ms. Gunderman, I believe it was Dr. Van Boven pointed out what struck me as an incredibly low success rate that whistleblowers have in front of your agency. Are those numbers accurate, and what are some of the reasons that whistleblowers typically lose when they're before you guys?
Let me address the first issue. The numbers are what they are, but as I said in my opening statement, those numbers are reflected of the cases that were adjudicated under the old law. So we're closing out on our fiscal year numbers for 14 that will fully reflect how the law has impacted the outcome. I believe your second question is?
Why? So you're saying that those numbers reflect past law.
Right.
So
Correct.
let's step into current. And I realize y'all haven't completed the numbers.
Right.
I'd like to see those numbers when they're done. But at least anecdotally, can you give me some idea why the whistleblowers are losing all the time?
Under the old law, it's quite apparent, which is why Congress changed the law. In addition, in changing the law, the Whistleblower Protection Enhancement Act, this Congress overruled a long series of cases by the Federal Circuit, which we were obligated to follow since they are our reviewing court. For reasons why they prevail, we really don't track why particular individuals prevail. We do track when cases are dismissed. A number of cases are filed untimely. A number of cases are dismissed because of failure to exhaust the administrative remedies through the Office of Special Counsels. There could be a number of other reasons which we don't track. We are a very small organization.
So now, Mr. Devine, you're head of an advocacy organization. Do you track how, or who, does somebody track the reasons people lose there? Somebody read the cases?
Yes,
Microphone, please, sir. Could you turn your microphone on, please, sir?
I'm sorry, yes, we do track the cases, and the WPEA is requiring the Merit Board to give much more detailed statistics and analysis of the causes. I'd like to say that while we haven't agreed with all the Board's rulings, this Board is unsurpassed at the leadership level, at the top, for fairness, objectivity, and an honest interpretation of the law. The problem that we've seen is more at the administrative judge level. The Board is not designed with the resources or the time to hear complex cases. The judges have to finish these cases in 120 days, and it's not always realistic when we're talking about major breakdowns in the system. And they don't have the political independence to challenge misconduct at higher pay grade levels than the judges frequently are. It's not designed for the cases that are the most significant for the WPA. It would be very helpful if the administrative judges were required in the OSC MSPB reauthorization to get some intensive training on the importance of this act and its mandate and what it means. And if they were upgraded from being just administrative judges to administrative law judges with more independence from political pressure.
All right, and Dr. Van Boven, I never cease to be stunned at what comes out of the VA. I mean, we've just had a huge scandal with wait lists and long wait times. It's something that we struggle with in my office in a lot of the casework that we do for individuals. I understand you're now separated, but I assume you still have some friends and contacts there. I know it's been barely a month since the President signed the reforms that we passed out of this House and the Senate passed. Is it getting better? Do you have any? Are we just spinning our wheels up here? Microphone, please.
I think that with firm determination and leadership, top-down cultural leadership, and accountability, that it will set an example. And I think that it can occur. The problem, as Mr. Devine just alluded to, it's that, there are stodgy, indoctrinated pieces of the fabric, that need to be, to mix metaphors, diuresed. We need an enema. The thing is that, we were wondering about why that 1% prevails. And I applaud the Merit System Director of Merit System Protection Board's new board's statement of saying the numbers are what they are. God bless her. Because the point is, once we open our eyes, and it's all about transparency, and when none of us like to admit our own transgressions, and I'm saying, hate the sin, but not the sinner. So I think, look, we can always change. That gets to the next point. Why did those people prevail? I'll tell you why they prevail. Because it was just like that line from Mr. Smith Goes to Washington. He says, basically, I'm paraphrasing, I was trying to look it up. He says, I'm never going to quit. He says, someone will listen to me eventually. Well, I felt the same way. When the VA tried to settle with me or make me go away. They said, Dr. Van Boven, it's been 4 years with you. It's been like round 13. And I said, are you kidding me? I was bluffing. I said, this is round 1. I was broke and unemployed. I said, I'm going to make this my life passion. So I think real solid determination. You know, Sam Houston said, do right and risk the consequences. This man did right, and he risked the consequences. And whether or not what a court says or what the hearings come out to say and how many people vote for and against, it doesn't matter. Because 120 years ago, we said it's okay to have slaves. They were wrong. And I think the same thing goes here. Once we open our eyes and say we've got to do something, then change will happen.
Thank you very much. I see my time is expired, actually over by 1.5 minutes, so I'll recognize Mr. Lynch for 6.5 minutes.
All right. Thank you, Mr. Chairman. Ms. Lerner, you got some data, though, in your testimony you shared with us regarding the old system and the new system under the WPEA. I know you didn't drill down on some of your written testimony, but what do you see in terms of, as Ms. Gruneman has indicated, there's been a spike in appeals, but you've also got some results, I think, right?
That's right. I mean, my microphone's on, right? I think you can look at it in a couple of different ways. To give it some perspective, I think that the rising numbers can be viewed as a very good thing. For one thing, people aren't going to come forward unless they feel like they're going to be protected from retaliation. And our numbers of complaints have gone through the roof. We, as I mentioned, have about 5,000 this year. And those are increases in both disclosures of waste, fraud, and abuse and health and safety issues and retaliation complaints. So more people are coming forward to make disclosures. More people are coming forward with complaints. But I think those are actually good things. Yeah. Whistleblowers who are coming forward are having more of an impact than at any time in our agency's history. And a couple other points. The numbers are also increasing, I think, because of changes at OSC. We've been very aggressive in trying to protect whistleblowers. The staff is using every tool that we have available to us to curb waste, fraud, and abuse. And we've had some very high-profile cases. And when we talk about changing the culture, when you get strong results, either through systemic changes like we've been able to see at the VA and the Department of Homeland Security and the Air Force and the FAA, that's a message that gets out to all Federal employees that they can make a difference. The other message that gets out is when you discipline people, they see the consequences of retaliating. And the Whistleblower Protection Enhancement Act has given us the tools that we need to bring disciplinary actions. And I think that that will also have an effect. Right. Education and outreach is also very important. And the fact that the administration is now requiring all agencies to go through our certification process, I think is also going to have a very positive effect on culture.
Right. If the person who complains is not there the next day, then that's a pretty strong signal that the administration is sending out there that that's not a good career move to speak up and to complain about the way things are being done. I do want to just take a step back and just say I thought the testimony here across the board, every single one of you has, I think, offered very thoughtful and important testimony, very helpful to me, I think. Mr. Devine, if there was you laid out those 5 points or five issues that you wanted to raise. The first one being, what was it? Sensitive job loophole. Do you think it is worthwhile for Congress to try to define that legislatively, or would judge-made law, would that suffice?
Unfortunately, Mr. Lynch, that's the only solution that's left. We've run out of options in the courts, and the civil service merit system will have to be legislatively reborn, independent of the national security sensitive.
Not the answer I wanted to hear. I could just see us trying to come up with a definition of sensitivity that would really provide the fullest recourse for whistleblowers. And I think about Dr. Van Boven at the VA, dealing with patients and patient records and security, confidential information, and it's right across government. I mean, the more important work we're doing, would obviously ring that bell for sensitivity and close down the recourse of complaining employees. We're going to have a real struggle with that, and we got to figure out a way to do that.
It's going to be tough, but I don't know, sir, if it's necessary to come up with a new definition of sensitivity with respect to civil service rights. That definition, that concept comes from the McCarthy era in 1954, and it's been dormant. It's been in a coma until the last two administrations, which have revived it. And the normal boundary for sensitive jobs has been when you have access to classified information, there's classified information is very broadly defined, and that's worked. And there haven't been any even accusations that it hasn't worked. This is simply a power grab to shift control of employment rights from the civil service system to officials with national security blank checks. And your point about the VA is very well taken. Unfortunately, we've been representing VA whistleblowers since the 1990s, and things are not getting better there. We're very grateful that the Office of Special Counsel has made this the first time in its history, has selected a whole agency to investigate for prohibited personnel practices, because they permeate it. The gentleman who came after Dr. Van Boven, Dr. David Tharp, who carried on his dissent for the next $12 million that didn't produce any research, the veterans groups have twice made him, in the last 4 years, twice made him the DVA Employee of the Year. He is so outstanding. The harassment of him was so severe that he volunteered for service in Afghanistan to escape the Center of Excellence. We've got a very severe problem.
Okay, I don't have much time, any more time to delve into it. But again, I appreciate the testimony of all the witnesses. Thanks for your help.
Thank you very much. We'll now recognize the Vice Chairman of the subcommittee, Mr. Walberg.
Thank you, Mr. Chairman, and thank you to the witnesses for some taking additional stance on difficult circumstances. Dr. Van Boven, if you would please describe the nature of the public health threat to the veterans from traumatic brain injury.
Well, I think the more you look, the more you find. Years ago, something like this had another name, and it was called shell shock, and you get over it. And in fact, Eric Hipple, who I speak with, the former Detroit Lions and sports concussion expert, spoke in terms of, well, it was a badge of honor to see the stars. But these effects are cumulative.
I sat on the plane with him yesterday coming here, so.
Fantastic, exactly. Well, you're why he didn't have dinner with me. I was just kidding.
Sorry about that.
No, he's a great guy. But the point is, he's a spokesman on the issue, and the issue is that is a cumulative effect. It's like radiation. We're learning that multiple concussions, they build up, and they can have additive effect. The same nodes or circuits that are messed up with there can set the stage to increase your risk of post-traumatic stress disorder, chronic traumatic encephalopathy, and be victims like Muhammad Ali. And so, we are now like saying, wait a minute, this is a disaster. We've got to work on this, and we've got to get serious, because if you don't look, you won't find.
How many vets has it struck?
Well, the veterans, gosh almighty, I think that is something that we haven't scratched on. We've just, look, in 05, just in soldiers, we said, oh, maybe there's about 2,700. 07, maybe 4,000. By 08, we said, well, maybe there's 150,000. And now we've decided there's 300,000. So it's a matter of a sensitivity. Now, veterans, my goodness, it's almost like I think it's going to take the same amount of time it took to recognize Agent Orange. Now, there are a lot of confounds, because guess what makes TBI worse? Alcohol, substance abuse, sleep deprivation, stressors. It's a toxic mix. And so it's no wonder, and I say this really tragically, that so many of our veterans of war, end up spiraling down socially and economically. They lose their wife, they lose their life, and they end up plummeting down to the VA system which takes the bottom 20% or less economically that give health care. There's over these million vets, for example, that the VA takes care of. I think that the problem is when there's, all these Federal employees, I think we need to help them by helping the people who are taking care of them so that when they see a problem, they don't fear retribution. It, in fact, might be a badge of honor rather than denigration to be a whistleblower. And so therefore, and then when you got OSC, it reminds me of Elliot Ness. Elliot Ness trying to take on the mob. Look, with 120 people taking thousands and thousands of claims with a $2.5 million budget, how can you expect them to do their job?
So concluding that research and continued research and consistent research is necessary, with respect to the funds for TBI research, where did the money go?
Well, there were ghost employees, people that didn't set foot in the lab, but they were taken from payroll. There was no accounting. There was no budgeting. So people,
And it was used for what?
Well, it was used for people that were on salary but not doing research. It was used for scanner time that was frivolously used for, I'm sorry, some kind of experimentation. I couldn't understand it, so I sent it out to 5 reviewers across the nation to kind of make sense of something I didn't make sense of.
And you found out how many vets were being helped?
0. Not one veteran was treated at the borough, and not one study has been done on veterans at Waco. 0. $13 million and 9 years later.
What motive did the DVA have to cover up the funding diversion instead of ending it? I mean, in your mind, what motive?
I don't know what that stands for. I'm sorry. Oh, yes, I'm sorry. Thank you. No, it's got a new name. He was asking about JACO, but it's now called the Joint Commission. That's why I was confused. So the motivation was very simple, and Ed Sherwood testified to it. He said, I'm getting ready, because we're in the bottom 10% of the Joint Commission for clinical performance, and this is all testimony, I'm paraphrasing, and he said, and the director's getting a lot of heat over it, and he says, and he told me, he says, I can lose my job because of this. He says, so before JACO comes in and tears us apart and we lose our job and get zapped by them, I'm quoting him, paraphrasing, he said, I get my friend, this administrator, to get in there and clean things up to keep the hospital accredited, and in turn, I give him research dollars, although he hadn't done any published work, any reports, any progress, no science. It didn't matter, because this was just basically money that he had power of. He wasn't a scientist, but he could just use it to help protect his job. That was the motive.
Mr. Chairman, could I follow up, or am I out of?
Without objection, we'll give you another minute.
No, thank you. Thank you. And that may be all it needs. Did this cover-up serve or obstruct WPA's efforts, their goals?
I think it was in a vacuum. I don't think WPA was anywhere in anyone's mind. And any time I would raise prohibited personnel practices, I was admonished and chastised during these internal tribunals, saying, we're not here to hear about these kind of what you think are illicit motives of retaliatory animus. We're here to talk about you, Dr. Van Boven. And so it was completely cut out.
And the peer review process didn't work.
Well, the peer review, if I may, part of the problem, you saw the chief of staff who reigned over his own grievance against him and found himself not guilty. I think that that's symbolic and representative of the VA system right now. Look, we have an Office Inspector General and Office of Research Oversight who's supposed to investigate his boss, the VA, but also answer to his boss. I mean, that's where you get all this incredibly diluted type of reports from ORO and the OIG. I think we need outside independent assessments. Healthcare is the same problem. Look, I'm sorry to inject this, because I'm a neurologist. I take care of patients. In 1999, the Institute of Medicine reported that the error is human, that there was 100,000 people dying in hospitals every year from medical mistakes. Okay? And so Congress was really up in arms, and we were going to do something. We're going to improve transparency in government. All right? 15 years later, The Leapfrog organization this fall has reported that that number of hospital errors causing deaths have quadrupled, 400,000 a year. It's the #3 killer of Americans now, behind heart attack and cancer. And if you go to the Joint Commission and speak to Hal Bressler, who's the chief counsel there, who's been there for 30 years, again, entrenched bureaucrat, and you ask him about, hey, I got some disclosures of problems because, who knows, but the doctors in the trenches, patients don't understand the details, and they shouldn't have to. But when doctors feel so much fear they can't speak out, well, guess what happens? Hal Bressler of the Joint Commission said, Roberts, to my lawyer, it's very simple. He said the problem is there's only been 2 cases ever of even though it's on the books that hospitals cannot retaliate for whistleblowing or sharing sentinel events that cause a patient's death. Although it's against the law and against our policies, there's no protections. We can't do subpoenas. We can't do investigations. Therefore, unless the hospital's stupid enough, and there were 2 cases in history, to say, yeah, we did it, we committed the murder, and punished him for reporting to you, unless they do that, Joint Commission can't do anything. We need laws. Think about it. You can, there's reports about you can save lives every year, thousands of them. Thousands every year, guaranteed, if you provide protection and support for physicians in hospitals.
Thank you, and thank you, Mr. Chairman.
Thank you very much. We'll now recognize the ranking member of the full committee for his question.
Thank you very much, Mr. Chairman. I want to say to all of you, I agree with Mr. Lynch. Your testimony has been extremely helpful, and I think there is no member of this committee in the Congress that fails to feel strongly about protecting whistleblowers. It's very, very important. And Ms. Lerner, as I listen to you, I think we are having some success. I think that's why you're seeing as much action as you're seeing, and that's a good thing. One of the reforms included in the landmark Whistleblower Protection Enhancement Act is a 2-year pilot program that allows whistleblowers to appeal a judgment of the Merit Systems Protection Board to any U.S. Court of Appeals with jurisdiction. Prior to the establishment of the pilot program, the Federal Circuit was the only court of appeals with authority to adjudicate whistleblower appeals. Mr. Devine, I understand that prior to the creation of the pilot program, the track record for decisions in the Federal Circuit was adverse to whistleblowers. I think it was something like 3 to 226 against whistleblowers for decisions on the merits. Is that right?
It degenerated to 3 and 232.
30. Oh, okay. Can you explain for us the concern that the pilot program was meant to address?
Yes, sir. It was meant to create healthy competition to translate the terms of the Act when there is dispute about them, the same as we rely on in every other aspect of the legal system, is having that difference of opinions and finding the truth from the composite. It's needed even more. The Federal Circuit has not ruled in favor of a whistleblower on the merits since passage of the WPEA. They have not been born again. And in the meantime, other courts of appeals have been coming in and, in fact, on whether the rights were retroactive. One court of appeals said we don't need to determine that because the Federal Circuit rulings all along were erroneous, and we're going to, by a court opinion, restore all the rights that the Federal Circuit took away. If we'd had all circuits review, we wouldn't have had to keep passing the Whistleblower Protection Act over and over again because the aberration of one hostile court would have been subsumed. We're very grateful that the House has passed legislation expanding the 2-year pilot test to 5 years, because the GAO study to see whether it worked or not is 4 years, and we hope that the Senate follows suit on that. I'd also like to supplement the answer on peer review as not being part of the solution at the DVA. It actually was the primary vehicle to attack the whistleblowers at the DVA. It's the classic Star Chamber proceeding in that they're not allowed to know the charges against them, they're not allowed to see the witnesses testifying against them, they're not allowed to present their own witnesses. It was a vehicle to be able to give an undefended, unreviewable attack on the whistleblower. It's in the same solution for retaliatory criminal investigations. If applied to retaliatory peer reviews, the same upgrade of language from legislative history to code from the 1994 amendments would allow people like Dr. Van Boven to defend himself before he has to go to the MSPB for a hearing.
Chairman Grunman, what impact has the all-circuit review provisions of the Whistleblower Protection Enhancement Act had on the Board's adjudication of whistleblower cases?
In short, not much. There have only been 4 cases appealed outside the circuit. And of the 4 cases, only 2 of them have been decided. The other 2 are still pending. So, as Mr. Devine indicated, if the goal of this law is to develop a wide variety of decisions from different circuits, then I would suggest that 4 decisions is not many.
At the time this provision was considered in the Protection Act, there was a concern that allowing for whistleblower appeals to other circuit courts of appeal would result in a flood of cases being filed in the other courts. My last question, Chairman Grunman, can you tell us how many cases have been filed in other circuits?
Just 4.
4?
4 total, on one hand.
And does that surprise you?
That's a difficult question to answer because it does take a while for a case to complete itself, complete its process, and then be filed in court. But we've been tracking this for 2 years, and all we've seen is 4 cases in total. And
so, Mr. Devine, you said you'd like to see that the legislation extended, the pilot program extended another 3 years?
Yes, sir.
Consistent with what we passed.
Very supportive of the bill the House passed to make it a 5-year.
And do you think that will make a difference? Do you think we'll see, it sounds like it's almost a little early to even make a good judgment on it, based upon what you said and what Chairwoman Grunman said.
Yes, sir. Well, we would love to see this made permanent as far as having a research base to demonstrate that. It's going to take more than a few years to develop an adequate number of cases for its statistically significant base.
Thank you very much, Mr. Chairman.
Thank you very much. We'll now recognize the Chairman of the full committee, the gentleman from Southern California, Mr. Issa.
Thank you, Mr. Chairman. This is one of those bipartisan things that brings together both sides of the dais, and so I'll follow up where the ranking member left off. Mr. Devine, if I hear you right, and if I look at what I think Mr. Cummings noted and Ms. Grunman, you said, which is there is no flood. So it's a relatively small amount of cases, and if we extend, and I appreciate the comment about making permanent, but if we extend it significantly, we do no harm. That the original short period of time was based on the assumption that there might be a flood and we might have to look at it. Is that pretty much consensus of everybody there?
Yes, sir. The predictions of a flood of cases, either for normal access to appeals courts or for jury trials in district court, have always flunked the reality test. They've been challenged prior to the passage of a dozen laws. For corporate whistleblowers at the district court level, for example, that flood has simply never occurred. It's been crying wolf over and over and over.
Let me just add briefly, as I'm obligated to do, that is a policy call for Congress. We don't take a position on it, but as I stated, the statistics do not provide much of a basis for anybody to draw any conclusions at this point.
So without taking a position, the numbers speak for themselves that there isn't a flood. And if we're going to evaluate the benefits and to be honest, see some of these cases come to maturity, it may take more time than was originally planned in the pilot.
That is correct.
Thank you. Mr. McLean, I want to thank you for the work that you've done to further, if you will, our awareness. The fact is that I look forward to your case being fully adjudicated. And I think, in fact, that's part of what we on the dais want to make sure is made available, is access to whistleblowers in a appropriate venue of their choosing, and then let's see ultimately when they trickle up to the Supreme Court how they're decided. Ms. Lerner, you've been a tremendous champion, and I appreciate the work that you've done. And this is a subcommittee hearing, and I know that before I got in here from other duties, most of this was done. But I want to take a moment and thank you for being, if you will, a good public servant. And quite frankly, for all of you, this hearing is about an area in which this committee is passionate. There's very little time left in this Congress, but if we can, in fact, do a further draft, the ranking member and myself, and get it introduced in the lame duck, we will. And that will take a little time, but this hearing today, Mr. Chairman, does help us. And so with that, I yield back.
Thank you very much, Mr. Chairman. We'll now recognize the gentlelady from the District of Columbia.
Thank you, Mr. Chairman. I'm very pleased that we're having this hearing, and I'm pleased that the chairman is here because the bipartisan Whistleblower Protection Enhancement Act, I think, is an indication of the concern of Congress, continuing concern, I must say. Indeed, as I listened to Ms. Grunman speak of having sat in my class in negotiations, I could only think that she's accomplished a lot more than any negotiations class could have given her, as she has risen to become chair of the Merit Systems Protection Board. Ms. Grunman, I've retained my tenure at Georgetown. I teach a seminar called Lawmaking and Statutory Interpretation. It's interesting that they can, as long as they're writing about statutory interpretation and how it mixes or links with what we pass, they can write on any subject they want to. And I note that I've learned something about your decisions and the decisions of the Federal Circuit, because any number of them over the years have chosen to write on what looks to be the conflict between the statute and what the board and the Federal Circuit have found. And then I note that, Congress has kept trying, kept trying to revise this statute. And I don't know if we need to try again. And I'm listening to some of the other ways to approach it that have come out in this hearing. I want to raise another issue that could affect far more Federal employees, conceivably virtually every Federal employee, and wipe out altogether the Whistleblower Enhancement Act. And I'm referring to Kaplan versus Conyers, a decision that reversed, what the Merit System Protection Board found in favor of the Federal employees. And the administration appealed all the way to the Federal Circuit and the Supreme Court, and the Supreme Court has let this stand. We use the word security very loosely. This is a frightening circumstance where a agency head or his designee can designate any position as security sensitive. Now, understand these are not positions that require a security clearance. So in the parlance of the day, most people would not understand that these positions are commonplace positions having nothing to do with security. And I want to ask the chairman if I could enter into the record the statements of two of the organizations that represent Federal employees on the impact
without objection
of this
to order.
decision. The first thing I thought about when I looked at this decision was, Whistleblower Protection Act means nothing here because there's no appeal whatsoever. It seems to me to go against everything that Congress has passed for the last 50 years. So if you think that that you're a victim of retaliation or that somebody is discriminating against you because of your religion or your race, leave alone you're trying to retaliate against you, there's nothing you can say because there is no recourse. So I have to say, is there any civil service system? And why isn't that an incentive for agency heads to simply disregard the system altogether? Now, I'm pleased to note that I have introduced a bill, and there are 2 Republicans and 3 Democrats in this committee who have sponsored this bill, and the Senate has adopted this bill, and it's a bipartisan bill now in the Senate. So you can see that this troubles the Congress itself. How to deal with a new wrinkle, I would call it, a new layer, first time I've ever heard of a layer, outside of security. So by calling these security-sensitive positions, these positions have been tucked right in there with positions where you need a security clearance. Now, you can understand where there's a security clearance and the kinds of information that could not, in fact, come forward. And these are not those positions. And I want to ask about the impact of the Conyers ruling, particularly on our attempts to protect whistleblowers and, for that matter, on federal employees across the country, across the board, recognizing that these first cases have involved DOD employees. But I read nothing in the regulations that would, even though most DOD employees, of course, do not have security clearance, but I read nothing in the regulations that would even confine it to DOD employees. And I note that the administration is trying to expand with further regulations the position it has taken by apparently writing regulations as I speak by the OPM and the Office of National Intelligence that would expand the federal positions labeled by this new label, security sensitive, to virtually all federal employees. I would like to hear, I would like to hear what all of you think. I suppose I should begin with Ms. Lerner, the special counsel, and to see if she has any role in advising the administration, which is, I think, taking the Conyers decision and raising it to even further levels that are unheard of in what has been called up until this point a civil service system.
Thank you for your question. Up until now, we have not had a role in advising the administration on this issue. I think it is important to note, however, that Congress has set up the Office of Special Counsel as a safe channel for disclosing classified information. So there's no doubt about the Office of Special Counsel's ability to responsibly and appropriately handle these cases. And I don't know that that has been mentioned or acknowledged. And I know you've introduced legislation, and as you mentioned, the Senate has too. But that's something to keep in mind in response to any objections to employees having the ability to appeal to the Office of Special Counsel.
Are you saying even secure positions?
Yes. Yeah, we can handle classified information and secure positions.
Well, Mr. Devine, do you think a legislative remedy is necessary? And I should ask Ms. Grunman, inasmuch as the MSPB, the Merit System Protection Board, ruled in favor of the employees and was overruled in the Federal Circuit. Do you think legislation, whether the legislation I introduced or has been introduced in the Senate or other legislation, could in fact correct this situation?
That is what I understand to be the goal of the legislation you introduced. But again, we have no position on policy. However, I can say that we have argued before the Federal Circuit precisely the types of statements and arguments that you've made here today, which is there would be no way for us or any third party to know whether somebody was removed for an improper reason, such as whistleblowing or retaliation for whistleblowing. Right now, because of the state of the law, we are bound to follow the Conyers-Northover decision, which precludes our review in its entirety. Let me also note that there are certain agencies out there that have only non-critical sensitive position. Everybody has some sort of sensitivity designation. So all the individuals potentially in that agency don't have any MSPB review.
DOD and others as well?
There are components within the Department of Defense. I think the labor unions, the statements that you submitted, you will find those comments. In the two particular cases that appeared before the Board, both these individuals were low-graded individuals. They're low-level GS employees who did not have access to classified information. In fact, their ineligibility was based on determinations, personal determinations, mostly financial, credit rating, bankruptcies.
Mr. Devine, just finally, could you say something about a legislative solution here, or is it, am I overwrought about what this does to the Whistleblower Protection Act, or for that matter, to Federal employees more generally?
To my great dismay, no, you're not overwrought. I've been working on good government rights through Federal employees making a contribution since 1976, and this is the most severe threat that's occurred. Whistleblower rights weren't immediately a target of the Conyers lawsuit, thanks to a White House decision. But trying to build whistleblower rights without a foundation of the merit system is like trying to build a home without a foundation. And when the security clearance precedent took away access to the civil service system in the MSPB, it was only a matter of time before whistleblower protection rights were next. It was inevitable. It happened. And there's not any question in our mind that the days are numbered for the Whistleblower Protection Act's survival if this decision is not reversed. I wish that it weren't necessary to have legislation, but because having worked 4 times to pass the Whistleblower Protection Act, we know how hard that is and how long it takes and how much work it is. But there isn't any other option left, and it shouldn't be controversial legislation. It's just to restore the status quo for a merit system in Federal employment that existed from 1883 to 2013. Without any incident due to the lack of sensitive job designations. This should not be a controversial bill, and there's no time to waste. Agencies, the Department of State, by agency, they're starting to make all their employees sensitive, non-critical sensitive. All of the IGs that we depend on to protect the whistleblowers are transforming their employees to be critical sensitive. The entire Border Patrol, where we've had some of our most significant whistleblowing disclosures, will all be non-critical sensitive. The government is being transformed from the rule of law to a national security spoils system.
Thank you, Mr. Chairman. I don't know if the administration knows what it's doing, but it's wiping out the civil service system, it seems to me.
Well, I think I thank you for your line of questioning, and I actually do want to follow up on it. I mean, I think we do have an issue of a sensitivity creep that, and I think Mr. Lynch pointed out our challenges in drafting legislation that is appropriate for that. I mean, I think clearly the case of someone stocking sunglasses is not going to have access to sensitive information, but I think the majority of us would agree that Mr. Snowden clearly had access to and exposed sensitive information. So finding the right place to draw the line is challenging there. I know it's certainly something that's going to be critical to Mr. McLean in his ongoing litigation as to how that goes. Anything we do now probably won't help you. You're in the court's hands. But I would appreciate, you don't have to come up from it now. I'd actually request that if you all in the next few days could send to the committee any thoughts you would have on how we draft that language to protect the legitimate whistleblower while still protecting our national security interest. And, a piece of it may be where that information is released. Clearly, flying overseas and releasing NSA information, as Mr. Snowden did, is not appropriate. But coming to a congressional committee or a special counsel or the Office of Inspector General with your agency might be an appropriate place to do that. And as we look at reworking that, at least I would appreciate each of y'all's thoughts and inputs on how to do that. I do have a couple of questions that I want to hit. And along with Mr. Devine, you offered your 5 concerns, your 5 loopholes, if you will, that you think need addressing. And I'd like to ask our other witnesses. I realize Ms. Lerner and Ms. Gunderman, as government employees, you're kind of in an awkward situation there. I would ask that if you feel comfortable speaking for yourself rather than the agency, someone with knowledge in the field, you're welcome to answer. I'll understand if you decline to answer. But if any of you all have any other suggestions for improvements in the law overall, I'd like to hear. I've given you an out, Ms. Lerner, but we'll start with you.
I think it's an important question. I would like to be able to give it some thought.
Okay, well, send it on with your thoughts on the language of the sensitivity creep, as we'll call it. Mrs. Grunderman?
Well, in terms of that particular issue, the Board has already spoken through its decision. I think we were rather clear on how we felt the issue should be handled. The Federal Circuit's disagreed with us. So certainly it is in this body's hands to resolve any outstanding issues. We will follow up with you, however.
Okay. Mr. McLean?
Throughout my case, the TSA just thumbed its nose at MSPB orders and Federal Circuit court orders. So the agencies are allowed to get away with what they do because I think the MSPB is too weak to uphold the orders, and they just go ahead and ignore them, such as switching out witnesses and ignoring deposition orders.
So some teeth some teeth in dealing with folks within agencies who disregard the whistleblower protection might be something you would suggest. Is that what I don't want to put words in your mouth.
It's hard to say because almost there was just never any accountability when the final decisions came from the full board and from and I think they're overwhelmed with a lot of caseload. It's good that this is opened up to multiple circuits because I think the Federal Circuit was overloaded with this, and now it's good that it's been spread around. So now they can spend more time to take a look at this.
Dr. Van Boven, you have any thoughts?
Well, with regards to...
Can you turn your microphone on? Sorry. Why am I the only one y'all forget to turn the microphones on with?
Sorry. Sorry. I don't have the expertise to comment on where to draw a line on sensitivity issues and whistleblowers' rights. But with regards to more broader suggestions on my plight and history and what are lessons learned and how can we improve that, I have the following suggestions. Number one, I think that there should be outside independent investigations with regards to wrongdoing in an agency. I think that there is a conflict of interest when you have to have the, as I mentioned before, a chief of staff who is making a decision and deciding about whether or not he did something wrong. So too, I think that there needs to be agencies that can have independent assessment. Oh, that's the OSC. So my feeling is that OIGs and the OROs and all the rest, it's a comedy of errors. I think that you should put teeth into OSC. 120 people, 2.5 million. I'm sorry, she didn't pay me for this, but I think that if you really want to do it, then give them the guns and the power to help people. And the second thing is we need more, cultural top-down saying, it's not the whistleblower who has the problem. He's blowing the whistle because something's wrong. And we need to try to fess up and give incentives, either the stick just like in hospitals. You have a patient that's staying too long, and they come back 3 days after you discharge them and they die, well, gosh, there's penalties there. And then also the carrot, in terms of we're going to have rewards for people who show real improvements in performances. And I always say to my patients, it's better to prick your own bubble than have someone else prick it for you. So I'm my own toughest critic in terms of, so they have rewards for those that point out problems in themselves before someone blows the whistle.
Thank you very much. And listen, I couldn't agree with you more about needing to get to the bottom of some of this, the culture problem. And again, I don't intend to beat up on the VA, but they seem to have asked for it. And hopefully we've been able to do that with our recent legislation. Finally, I want to wrap my questioning up, and we'll give Mr. Lynch his a second round of questioning when I'm done with a broad overview. Each one of you is involved directly with whistleblowers. Some of you are whistleblowers yourselves. This committee relies heavily on whistleblowers. Quite frankly, the American people rely heavily on whistleblowers. It's the people who have the courage to do the right thing and point out what's going wrong, sometimes at their own peril. We're trying to fix it where it isn't as perilous for them. But these are true American heroes who do the right thing and come forward. And I want to give each one of you the opportunity, if whoever's watching this on the web that might be thinking about being a whistleblower, or somebody who's reading the transcript of this hearing that's thinking about being a whistleblower, what would you take 10 or 15 or 30 seconds, what would you say to somebody who's thinking about becoming a whistleblower? And we'll go down the line and start with Ms. Lerner. When we're done, I'll pass on to Mr. Lynch.
I think what I would say to a whistleblower is that they have a lot of avenues to come forward. And I particularly want them to think about the Office of Special Counsel. We are a robust, active agency. We are understaffed, but we are getting terrific results for whistleblowers. We have a record number of corrective actions, almost 200 this year on behalf of whistleblowers. We need people to come forward with their disclosures, and I think the results that we've gotten because whistleblowers have come to us show the value. We've gotten amazing results at the Air Force, the FAA, the Department of Homeland Security, and most recently at the VA. And just today, in fact, the new Secretary of the VA, I believe, testified that he wanted everybody to be a whistleblower at the VA. Now, probably going a little bit too far, but the message is, I think he wants people to know that the culture is going to change at the VA. And we need whistleblowers to come forward in order to make our agencies, our government, better and safer for the American public.
Ms. Grundman.
Thank you. One of our functions is, of course, the studies function, and we have routinely seen that Federal employees still perceive evidence of prohibited personnel practices, one of them being reprisal for whistleblowing. So that creates a culture problem. We commend this body for taking the initiative to change the law, to create new avenues for whistleblowers to come forward. But ultimately, as Ranking Member Lynch mentioned at the beginning, the culture needs to change within an agency, whereby employees are encouraged to come forward and whereby their allegations are investigated. And when the investigation is done, if there is no wrongdoing accomplished, employees should be told an investigation was completed and you did the right thing by coming forward. So the culture change is what needs to occur, and it's educational and it's long-term.
Thank you very much. Mr. McLean.
I would advise people that your whole life is going to change. It doesn't matter what you believed, what was doing right at the time. Years down the road, everything that you said and done is going to be highly scrutinized. A lot of your friends at work are never going to talk to you again. You could lose your job. It's a huge, huge risk. Prepare for the absolute worst.
Would you do it again?
Absolutely. I was a law enforcement officer. You paid me 3 times, 4 times more than your average Federal worker to make split decisions in one of the most dangerous areas to to enforce the law. So it was my duty. It was my oath to do what I had to do. And at the time, I believed I was doing everything to protect the public. So absolutely, I took that law enforcement oath, so I would do it again and again. There's better people than me have given up worse, given up more.
Thank you very much. Dr. Van Boven.
Well, right now.
Microphone.
I'm sorry. Right now, I think that the applause for whistleblowing is frustratingly anemic at best. I think that the current culture is that you have to be masochistic, a Don Quixote, or want to have financial ruin and have and have Pyrrhic victory, and a probable divorce. And these are the statistics. Look at Lois Jensen, of the class action, first class action lawsuit in America. I lived a few miles from where she was, up in Virginia, Minnesota. After 12 years, and she and a half dozen people got $600,000, but her life was ruined, and she's still a wreck. If we think in terms of Mr. Wiegand of the tobacco industry, he's been psychologically devastated as a result of all of these things. I myself, thankfully, I survived, but barely. So the bottom line is, we got Boy Scouts and Girl Scouts, and you give them badges. We should start early and really make it happen. Where's my badge? I think that if we really want to give positive reinforcements, then make it visible, and to say you are a hero and mean it. Because right now people say, oh, you want to applaud a whistleblower, but they don't want to be too close to the whistle.
Thank you very much. And Mr. Devine?
Mr. Chairman, the first thing I would say is that this is the unsurpassed is a crossroads decision in your life, which will never be the same. Make this decision with your family and the loved ones who are depending on you, because they're going to be affected by it. And the cost will be severe if you're going to make a significant difference. But if you're willing to pay the price, you can make a difference, because there's nothing more powerful than the truth. So think it over. Number two, do your homework. It's the highest risk decision you'll be making, and you have to do the most advanced preparation. So get Get's book, The Whistleblower Survival Guide, a handbook for committing the truth. It's based on the experience of 6,000 whistleblowers' lessons learned. And the third thing I'd advise is, if they're a federal civil servant, to convince Congress to give you rights that are analogous to those of corporate employees who have full, normal access to court to enforce them.
Thank you very much. Mr. Lynch?
Thank you. Normally I would say the witnesses have suffered enough, but I do have a couple other questions. Just a sort of an anecdote. In Boston, the VA has switched over. They have done this whole whistleblower support protocol, and so we've had. I was just involved in a case at one of my local VA hospitals. I've got 3 where the whistleblowers' complaints were borne out, and the system was changed because they came forward. It's not entirely a happy ending, but I have to say that they came forward, they pointed out deficiencies, and those deficiencies were changed, somewhat reluctantly, but they were changed. So there is the opportunity, I think, to educate our folks, our managers, to implement these programs to make it more conducive for people to come forward. And I think that part, we need to do better, and we need to do it all across government. And I think that will help change culture in a way. If we are seen as supporting this, and maybe by that way by that action the risk that Mr. McLean talked about. And I hate hearing that you take your life in your hands. And maybe we haven't really drilled down on Mr. McLean's case, but I'll do that now. You served as an Air Marshal back in 2003, and what I understand is in August 2003, TSA proposed a change in policy to cancel all Air Marshal coverage on long-distance flights for that time period. And it coincided with a period of high risk on the airlines, long-distance airlines, from Al-Qaeda. Isn't that correct?
Yes, sir.
And you came forward after you received your notice, which was non-classified at the time, and you complained about it. And you also, as you described earlier in your testimony, you went to the press, and they confirmed it with other air marshals. And instead of being rewarded for your diligence, of course, TSA had to change their policy. You were fired in, what, 2006?
Yes, sir.
And the excuse they used was that they had gone retroactively and in 2006 changed their classification of your text messages that you received to classified. And so you were in a sensitive position. Is that what their argument is, basically?
They retroactively designated my disclosure with an agency-regulated, unclassified marking called sensitive security information, years after the fact.
Right. And so you were fired for that.
Yes, sir.
Tell me and tell this committee about the difficulty you've had in getting employment as an air marshal or other employment since that job action.
I applied for almost a dozen police agencies in Southern California, and none of them even came forward and said, we don't want to hire you because you got fired from the TSA. I simply got, thanks for applying. You weren't the most qualified. Maybe try again in the future. I only had a high school diploma, didn't have a college degree, so it was very difficult for me. And most of the jobs I've been from jumping job to job with commission-only door-to-door sales jobs. It's about the only thing I could find. So yeah, I was pretty much blackballed from being a veteran, Air Force veteran, a Border Patrol agent. The man who fired me said I had an impeccable, perfect record. It didn't matter. I still couldn't get a job as a cop again.
What exactly were you told about how your career may be harmed if you didn't remain silent? Were there any warnings given to you about what you were doing coming forward?
After the fourth proper channel that I went through, which was finally a special agent with the Inspector General, he simply said, the agency went broke. This happens. There's nothing you can do. There's nothing we can do. You don't want to cut your career short over making a big deal about this. And that was at the final time I was advised not to go further.
Well, I think the circumstances that you find yourself in is a disgrace to us as federal employers, both yourself and Dr. Van Boven. I think your example is extremely instructive to us going forward and trying to devise a policy where employees like yourself will be protected during this process, and that I think you prevented a dangerous situation from being put upon the public, the flying public, and it's a disgrace that you're being punished for that. So. Thank you for your testimony. As I said, I just wanted to spend a little time on your case and and amplify it a little bit. Hopefully it will help you going forward.
Thank you, sir.
Thank you.
I'd like to thank everybody on our witness, especially our whistleblowers. I'm going to echo what Mr. Lynch said, that it is a disgrace, and I hope you take away from this, the members of this subcommittee, I think unanimously are committed to making the situation better, and we're going to keep working on it. Again, thank you all for your testimony. The subcommittee stands adjourned.